Some of the worst crimes ever known have been committed during the 20th century. Millions of children, women and men have been victims of unimaginable atrocities that have deeply shocked the conscience of humanity. Unfortunately, in the past, such crimes have often gone unpunished. Millions of people died during 2 world wars and in fighting in Rwanda, Sierra Leone and the former Yugoslavia. Although some of the highest military and political leaders accused of committing crimes during these conflicts have been prosecuted by temporary international courts, many crimes remain unpunished. The International Criminal Court is the first permanent court with jurisdiction over the most serious crimes threatening the peace, security and well-being of the world. In 1998, during the Rome Diplomatic Conference on the International Criminal Court, 160 countries negotiated a treaty to design the world's first permanent international criminal court. On the 17th of July 1998, after 5 weeks of intense negotiations, 120 nations voted in favour, and on July 1st, 2002, the Rome Statute entered into force after ratification by 60 countries. The court is located in The Hague, the Netherlands.
The court has a mandate to try individuals aged 18 and above at the time the crimes were committed and to hold them accountable for the most serious crimes of concern to the international community, that of genocide, war crimes, and crimes against humanity committed after 1st of July 2002. The court may exercise jurisdiction over these crimes only if they were committed on the territory of a state party or by one of its nationals. These conditions do not apply if a situation is referred to the prosecutor by the United Nations Security Council, whose resolutions are binding for all UN member states, or in a situation in which a state makes a declaration accepting the jurisdiction of the court. In addition, the court will also have jurisdiction over the crime of aggression once a definition has been adopted by the Assembly of State Parties.
The court is intended to complement, not to replace, national criminal justice systems. It can prosecute cases only if national justice systems do not carry out proceedings or when they claim to do so, but in reality are unwilling or unable to genuinely carry out such proceedings. This fundamental principle is known as the principle of complementarity.
Since 2002, the court has developed into a professional institution with a 4-part structure. Although housed in the same building, the 4 organs of the court carry out distinctive mandates: the Presidency, Chambers, the Office of the Prosecutor and the Registry.
The Presidency is made up of 3 judges. They are the President and 2 Vice Presidents. The Presidency manages the court, represents the court to the outside world, and helps to organize the work of the judges. The Presidency is also responsible for carrying out other tasks, such as supervising the punishment imposed on persons found guilty by the court. The decisions in the courtroom are taken by the judges. The judges work together in small groups called chambers. There are 3 kinds of chambers at the court: the pre-trial and trial chambers. Each consists of 3 judges per chamber, and the appeals chamber has 5 judges.
I, Elizabeth Odio Benito, solemnly undertake
that I will perform my duties and exercise my powers
de juge de la Cour pénale internationale en tout honneur et dévouement,
and that I will respect the confidentiality of the investigations and prosecutions
and the secrecy of deliberations.
The court is composed of 18 judges who are elected for terms of office of 9 years by the Assembly of States Parties. The judges are chosen from among persons of high moral character, impartiality and integrity, who possess the qualifications required in their respective states for appointment to the highest judicial offices. The election of the judges takes account of the need to represent the world's principal legal systems, a fair representation of men and women, and equitable geographical distribution.
The pretrial judges take decisions that have to be taken in court before the trial begins. This includes the decisions to issue arrest warrants and to confirm or dismiss the charges against the person suspected of a crime within the jurisdiction of the court. They also ensure that the investigation respects the rights of the defense, the suspect and his lawyer, and protect the rights and interests of the victims and witnesses. The trial judges decide whether the accused person is innocent or guilty of the crimes concerned. If they find him guilty, they decide on the punishment of the crime and on any reparation to be awarded to the victims. They must also ensure that the trial is fair, does not take too long, that the accused person is treated fairly, and that the victims and witnesses are protected. The appeals chamber has all the powers of the trial chamber during the proceedings on appeal. The 5 judges that constitute the appeals chamber can confirm, reverse, or amend the decision or sentence, or order a new trial before a different trial chamber.
The Registry is the biggest organ of the court. Its core functions are to provide administrative and operational support to the judiciary and to the office of the prosecutor. It also provides support for its own activities concerning defense, victims, communications and security. It helps to service the court and develop effective mechanisms to assist victims, witnesses and the defense with a view to safeguarding their rights in accordance with the statute and the rules of procedure and evidence. The Registry is headed by the Registrar, who is the principal administrative officer of the court. The aim of the services provided by the Registry is ultimately the conduct of fair, effective and expeditious public proceedings.
Beyond its activities at the court's HQ, the Registry is in charge of field operations in support of investigations and prosecutions. It supports the work of counsel teams, both the defence and legal representatives of victims, as well as activities undertaken by the Trust Fund for Victims. In the field, the Registry is responsible for ensuring the protection of witnesses, victims, and the effective participation of the latter. It's also involved in outreach activities with the affected communities.
The Office of the Prosecutor is independent from the other organs of the court. It is responsible for investigations into crimes and for the prosecution of those crimes in the courtroom. The mandate of the office is to conduct investigations and prosecutions of crimes that fall within the jurisdiction of the court. That is, the crime of genocide, crimes against humanity, and war crimes.
The procedural regime of the International Criminal Court is largely a combination of 2 different systems, common law and civil law systems. It always starts with the initiation of an investigation.
I, Fatou Bensouda, solemnly undertake that the prosecutor may start an investigation upon referral of a situation by a state party or the United Nations Security Council. I may decide to start an investigation on my own initiative on the territory or against nationals of a state party. In that case, I need to request authorization from the pretrial chamber. Before the commencement of a formal investigation, it is required to gather and assess relevant information in order to determine whether there is a reasonable basis to initiate an investigation.
It is in the authority of the pretrial chamber to grant or deny the Office of the Prosecutor leave to initiate an investigation. The pretrial chamber makes preliminary determination as to whether the case falls within the jurisdiction of the court.
Once the formal decision has been taken, the Office of the Prosecutor commences investigations in the areas where it is believed that the alleged crimes took place. In order to understand the situation and context in which crimes were allegedly committed, the investigators in the field interview witnesses and suspects and collect documents and materials which will enable them to determine the way in which crimes were committed and to identify those persons most responsible for the commission of such crimes.
When the investigators return from the field, all the evidence they've collected is thoroughly examined in order to piece together the chain of events and establish the criminal responsibility of those who designed the plans, gave the orders, or otherwise supervised or failed to prevent the commission of crimes.
It is a policy of the Office of the Prosecutor that investigations focus on those individuals who bear the greatest responsibility for the crimes committed in a situation under investigations. The application for a warrant of arrest and supporting material is then presented to the judges of the pretrial chamber.
If the pretrial chamber is satisfied that there are reasonable grounds to believe that the person sought has committed crimes within the jurisdiction of the court, and the person's arrest appears necessary, it will issue a warrant of arrest.
The court has no police or army to enforce warrants of arrest, so it has to rely on the cooperation of states. It is the duty of the registrar to communicate a warrant of arrest to the state parties. When the state party receives a request for an arrest or surrender, it shall immediately take steps to arrest the person in question or inform the registrar that the person charged is available for surrender.
Within reasonable time after a suspect has surrendered or appeared voluntarily before the court, the pretrial chamber holds a hearing in the presence of the prosecutor, the suspect, and his counsel to determine if the charges can be confirmed or not.
I will just summarize that in this case, the prosecutor brings against Dominic Ongwen 70 charges.
A confirmation of charges hearing is a public hearing at which the judges should decide if there is sufficient evidence to believe that persons charged might have committed the crimes based on evidence presented by the prosecutor and the defense. The purpose of the hearing is to ensure the fairness of the process by protecting the suspects of facing charges if there are no substantial grounds and evidence.
The floor is to the defense of Mr. Ongwen.
If the charges are confirmed, the Presidency constitutes a trial chamber to try the case. The trial chamber's main task is to ensure a fair and expeditious trial, conducted with full respect for the rights of the accused and the protection of victims and witnesses. The trial is generally held in public. The chamber can, however, decide to exclude the public from some parts to protect confidential information, or for reasons of victim and witness protection.
All rise, we will there.
For the first time in the history of international criminal justice, victims have the right to participate in the proceedings and request reparations. This means that they may not only testify as witnesses, but may also present their views and concerns at all stages of the proceedings. It is most likely that they do so through legal representatives. Victims can request various types of reparations, including restitution, compensation, or rehabilitation.
The trial chamber determines whether an accused is innocent or guilty of the charges, and if guilt has been determined, may impose a sentence of imprisonment not exceeding a maximum of 30 years, or in cases of extreme gravity, life imprisonment. Financial penalties may also be imposed. The trial chamber may order reparation to victims, including restitution, compensation, and rehabilitation.
The convicted person and the prosecutor may appeal against a conviction and sentence. The prosecutor may also appeal against acquittal. The appeals chamber may reverse or amend the decision on a conviction or sentence and may order a new trial before a different trial chamber. It may also revise the final judgment of a conviction or sentence.
Persons detained under the authority of the International Criminal Court are kept in custody at the ICC Detention Centre, located within a Dutch prison complex in Scheveningen in The Hague. The detention centre functions to hold in safe, secure and humane custody those persons detained under the authority of the ICC, fulfilling the highest international standards. Whilst in the detention facility, the court has to ensure the mental, physical and spiritual welfare of detainees within an efficient system of detention. Detainees have rights that are guaranteed by various court rules and regulations. They're entitled to privacy with their defence lawyers, diplomatic states representatives, visits by their minister or spiritual advisor, as well as family members. They have access to fresh air, recreational time and sports activities, access to library and books, news, television, computers and medical care within the facility. Detainees are provided with food, but they can also cook themselves according to their taste and cultural requirements. Detainees are presumed innocent until proved guilty, so they're not sentenced and in jail, but awaiting trial. If they are sentenced, they will be transferred to a prison outside of the Netherlands, to a state that has voluntarily agreed to accept the prisoner. For the first time in the history of international criminal justice, victims have the right to participate in proceedings and request reparations. This means that they may not only testify as witnesses, but may also present their views and concerns at all stages of the proceedings.
To assist victims, the court has established within the Registry the Victim Participation and Reparations section and the Victims and Witnesses unit. The VPRS assists victims in relation to their applications for participation in the proceedings and reparations. It also assists victims in obtaining legal advice and organizing their legal representation. The Victims and Witnesses unit provides protection and psychological support to victims who appear before the court as witnesses. This unit is also responsible for witness protection programs. The Office of Public Counsel for Victims provides support and assistance to the legal representative of victims participating in the proceedings, as well as asking for reparations. It is also available to provide legal assistance to victims without charge. This is a new step in international criminal justice, which seeks to ensure the effective participation of victims before the court.
The court may order various types of reparation to victims, including compensation, restitution and rehabilitation. At the end of a trial, the trial chamber may decide to order a person convicted by the court to make reparations to victims of crimes for which he or she has been found guilty. The court may award reparations either on an individual or collective basis. The Assembly of State Parties established the Trust Fund for Victims in order to help implement reparation awards ordered against convicted persons. The Trust Fund for Victims forms an essential part of the International Criminal Court's innovative mandate towards victims and is an acknowledgement that justice for genocide, crimes against humanity and war crimes cannot be met by retribution alone. The Assembly of States Parties is the court's management oversight and legislative body and is composed of representatives of the states which have ratified or acceded to the Rome Statute. The Assembly of States Parties has a bureau consisting of a president, 2 vice presidents and 18 members elected by the Assembly for a 3-year term, taking into consideration equitable geographic distribution and adequate representation of the world's principal legal systems. It has a permanent secretariat at the seat of the court in The Hague. The Assembly of States Parties makes decisions on various issues, such as the adoption of normative texts and the budget, the election of the judges, and the election of the prosecutor and deputy prosecutors.
The court is a testament to the international community's commitment to putting an end to impunity and to establishing a new system approach based on respect for justice and the rule of law. States, international organizations, and civil society have worked for years to develop a system of international criminal justice fit for humanity in the 21st century. Over the past 15 years, the International Criminal Court has gone from an idea on the agenda of the General Assembly 6th Committee and International Law Commission to a robust judicial institution built on the highest principles of international law. It is our collective responsibility to ensure that this system of international criminal justice becomes credible, effective, and that it prevails.